Hi, and welcome to this podcast on technological evolution and arbitration. I have with me Mr. Manish Dembla, a partner in our dispute resolution practice. Manish, thank you so much for being here. I wanted to understand, according to you, what has led to this entire surge of use of technology in arbitrations?
Anirudh, if I had to pick one catalyst, it would be COVID-19.
Okay.
In fact, the pandemic has been like a tech tornado, sweeping the entire legal profession and pushing us all into the digital age. In fact, I had made the switch from bulky hard copy files to an iPad in 2018 itself.
Okay.
And at that time, I could see most arbitrators and opposing counsels still struggling with mountains of paper. But fast forward to 2020, everyone suddenly became comfortable with digitized files, and it was all because of the compelling circumstances created by the pandemic.
So, when we talk about it, and that's a very interesting thought. So, how do you see the pandemic change the way in which the entire documentation was handled in all these arbitration proceedings?
So, Anirudh, post pandemic, we are increasingly witnessing arbitrations where documents are being filed only in soft copies, no hard copies at all. And what this does is that one, it is sustainable, it's good for the environment, it reduces the need for physical storage space, and most importantly, it opens up various other possibilities which were not available before.
Interesting. So, what are these? You talk about these new possibilities. So, could you sort of shed some light into what are these new possibilities we're talking about?
So, Anirudh, to give you an example, we've started the practice of serving hyperlinked pleadings and witness statements in arbitrations. Now, imagine that you're going through a pleading, and if there's any document referred anywhere in that pleading, you can just click there and the document opens up. So, you no longer have to rummage through piles of paper to find what you're looking for, which you traditionally used to do.
So, okay, councils have sort of obviously moved on with such technology and adapted it so beautifully. Is it the same with the arbitrators, the tribunals? Are they also on board with things like this?
In fact, a lot of arbitrators have been asking for digitized versions. They say we don't need hard copies, especially in construction and infrastructure arbitrations. So, for example, in a recent infrastructure arbitration, along with a statement of claim, we filed 91,000 pages of documents, right? And it would require us to hire a truck to deliver those documents to three arbitrators. And this is especially true if the arbitrators are in a different country,
Right.
right? So even the courier cost, the logistics costs are too much. So the arbitrators say that okay, you send us the hard copies of the pleadings themselves and the witness statements themselves without the supporting documents. Let the documents come by way of digitized files
Yeah.
and ensure to hyperlink the pleadings and witness statements so that we can navigate it easily.
So, would this have also impacted your overall document management, data management systems that would typically not be frequently used earlier?
In fact, Anirudh, the increased digitization has led to the proliferation of various online case management systems. What happens is that you upload all your pleadings and documents on these platforms in a searchable format, and it's like a virtual filing cabinet where everything is already organized for you.
Okay.
And you don't have to, again, as I said, you don't have to really look through piles of paper to find what you need. You can just put a search term. Suppose there's a dispute about whether a particular, for instance, auto location hut in a railway contract uh, is a variation, right? So you just search for the term variation and you'll find everything that uses that word in the entire arbitral record. So that has made it very, very easy. It's all at one place. Everyone involved in the arbitration is looking at the same organized record.
Wow. So, the world is talking about AI nowadays. So I wanted to understand that with so much of adoption of technology and considering usually these arbitration and legal cases, etc., involve a lot of confidential information that we're putting out there online. Do you see any risk with the like with the additional use of technology or additional reliance on technology?
So Anirudh, there are two aspects to it. one, as you said, confidentiality of data.
Hmm.
Arbitration is definitely intended to be confidential,
Okay.
right? And when you are putting all such data to a third-party platform,
Hmm.
or you're uploading it to a Dropbox or to a Google Drive or OneDrive, you need to make sure that your data is secure, right? So you need to have encrypted databases, encrypted cloud platforms where you are uploading these. When you're using an online case management platform, you need to have your non-disclosure agreements, confidentiality agreements in place. And obviously, there will be reps and warranties from those organizations in the agreements that all your data is secure, it's confidential, and we're not accessing it, and we're destroying it after your case is over. And you have to rely on it because you can't do much more than that. And if anything happens, parties will make a claim against those platforms,
Good.
right?
Are these the mitigating measures, or do you think,
So before I come to mitigating measures, I would come to the second aspect. One is data.
Sorry. Yes. Yes. Please.
The second aspect is that there could be various challenges that arbitral tribunals may face going forward. Take the example of a witness deposing remotely in an arbitration. A party could use a deepfake model to impersonate a witness in real time. Now, such a model could be trained to respond to questions in cross examination in a predetermined manner. Now, this is something which may sound like right out of a sci fi movie,
Yeah.
but it's a very real prospect given the exponential rate at which generational AI is improving. Another challenge that I see is that how do arbitral tribunals trust in the audiovisual evidence that is presented to them? If you rely on it straight away and if it is falsified, it can influence the outcome of the arbitration.
Correct.
On the other hand, if you engage experts to verify the authenticity of such audiovisual evidence, it will add to the time and cost, which is basically opposed to the whole concept of arbitration because you want to save time and cost.
Right.
Then, with the growing mistrust in certain kinds of evidence, it may give rise to a strategy which some practitioners call as the deepfake strategy or the deepfake defense strategy, where you try to sow seeds of doubt regarding some evidence, even when you know that it's authentic.
To destroy the credibility of the evidence or the person that's
Yes,
interesting. So,
yes,
what would your suggestion be? How does one go about mitigating these issues?
right. So, as far as the first aspect is concerned regarding data, I said, you'll have encrypted databases where you're uploading it, and you'll have your agreements in place with the online platforms with reps and warranties and indemnities. And as far as the other dangers are concerned, I think the answer ironically lies in technology itself. So we need to have advanced tools which can detect deepfakes with a high accuracy. We need to have specialized software, video conferencing software that will be able to detect if any participant is using any AI model
Hmm.
during the hearings. This may give rise to privacy concerns because you'll have to give access permissions to your device to these softwares. But the good news is that at least for now, the stage at which the technology is, a well-trained human eye can still spot most deepfakes, especially in real-time scenarios.
Okay. Okay. So, so much I've been hearing about the use of technology, growing reliance on technology. Um, it's been constantly bothering me that, with so much of artificial intelligence coming into play, are we looking at a situation where human beings can actually be replaced by technology overall in this entire arbitration scenario?
Uh, Anirudh, that's a very intriguing topic, and this again involves two aspects. One is the arbitrators,
Right.
and the second is the lawyers. Right
Yeah.
now, as far as arbitrators are concerned, there have been studies where AI models have predicted the outcome of US and European cases with a surprising level of accuracy.
Wow.
So some people have started arguing that you don't need lawyers,
Hmm.
you don't need arbitrators.
Hmm.
We'll just feed all the information into an AI system, and it'll give us an outcome. Now, there's a lot of problem with this kind of an approach, in my view. The first thing is that it is completely different to predict an outcome of a case and actually acting as an arbitrator in a real dispute. Because when you're acting as an arbitrator, you have to give a reasoned award.
Hmm.
When you're predicting outcomes, the AI is just running some algorithms and giving you a conclusion that according to me, this party is likely to succeed. That's one. The second issue is how do you train the AI models, because they'll need extensive data to be trained, which is hard to come by for arbitrations because arbitral awards are confidential. Right? Now, one potential workaround could be that you train the AI models on court judgments. But in this case, the question arises the judgments of which jurisdiction's courts, because parties will specify different governing laws for their arbitrations. There could be cases where the governing law of the arbitration, the seat of arbitration are different, and there's also an arbitral institution involved. So the AI has to navigate between the governing law, the curial law, and the rules of the arbitral institution, which makes it even more complex. Okay. Then the second problem with training the AI on court judgments is that it leads to judicialization of arbitration proceedings. Now, what is judicialization? Arbitration is intended to be more flexible in terms of procedural matters. And human arbitrators know that and they can be more flexible. But if there's an AI which has been trained exclusively on court judgments, it may not have that flexibility.
The thought process then becomes aligned to what a judge would in typical.
Yes.
Very interesting.
Right.
Please.
And just to add to that, while there are many advanced AI models, it is still perceived that they lack that human empathy and the intuitiveness of making a decision. But even if we are going to overcome all these hurdles someday, parties are still going to be hesitant, in my opinion, in entrusting an AI with adjudicating their disputes, especially where the disputes are high stake or they are complex.
Very interesting, Manish. I must say you opened my eyes to a lot of facets of the interaction between technology and arbitration, which I wasn't honestly aware of. Thank you so much for taking our time to do this with us today.
Thank you, Anirudh. It's a pleasure.
Thanks.